Hi, my name is Peggy Hoyt, and I'm with the law offices of Hoyt and Bryan. We're located in the Oviedo, Florida area, and we call ourselves Family Wealth and Legacy Counselors. I'm going to share with you today a story about some business partners. There were two very successful businessmen who invited a third partner into their business, and this was a construction industry business, and the company was doing very, very well at the time. In fact, they had gross sales of approximately $25 million. And as a result of the combined business interests, the partners decided to get together and do a funded buy-sell agreement. And so we worked as a team to negotiate the buy-sell agreement and came up with terms and conditions that would be acceptable to everybody. And then the buy-sell was actually funded with life insurance in the event of death, and there were some other provisions built into the plan in the event of disability. Well, one of the things that we had talked about during this process was the formula for what would happen if one of the partners died and what the buyout value of the business would be. And the business continued on successfully for a number of years. Then, very unexpectedly one day, one of the partners was diagnosed with a brain tumor. And as part of his illness, he assured his wife that if anything happened to him, that his interest in the business was worth $1 million. And in fact, the life insurance that they had purchased was $1.25 million. So he had this built-in expectation that his wife was going to receive $1 million in the event of his death. Well, as you know, the economy didn't do very well a few years ago. The construction industry really suffered, and during that time period was when this business partner passed away. And after his death, of course, his wife was interested in the $1 million value that he believed he had in the business. Well, at that time, it became abundantly clear that the formula that was built into the buy-sell agreement provided $1 million based on the fair market value of the company if the company was operating profitably. And at this time, the company was actually operating at a deficit and in fact had significantly more liabilities than it had in revenues. And in a strict partnership sense of the word, the deceased partner's family probably should have had to contribute to the ongoing operating costs of the business. The other two partners had been contributing their own money to the success of the business, or at least to keep the business solvent. So after much negotiation and a lot of anxiety on the part of all of the partners, we did come to a mediated settlement. We agreed among ourselves how the proceeds of the life insurance should be split up, some for the surviving widow and some for the remaining partners, to not only pay themselves back for the money they had injected into the company, but also for the ongoing operation of the company. I think the good news in this story and why it turned out to be a success was that we did have a written set of buy-sell agreements, so everybody ultimately knew what to expect, even though the initial expectation was misplaced. And we avoided litigation, and ultimately everybody went away feeling like they had successfely been a winner in this particular situation. So it's just a lesson to all of us that negotiated written agreements are going to be a lot better than nothing. So have a great day.